Welcome to The Agent's Angle, the show where we often have to pose questions relating to the football agent world that no one else asks, seemingly because they don't want to hear the answers. With me, Jonathan Booker.
And me, Peter Paleologus. This week we look at a topic that has grabbed the attention of many across the football world, not least the lawyers and football's regulators, with signs that a decision on the rights of players in an ongoing case could potentially have an impact on a seminal scale similar to that of the Bosman decision.
As well as player rights, we also consider the importance of communication for agents with the likes of clubs and the authorities, as a lack of record keeping or poorly thought out communication could land agents in a lot of trouble.
All that to come on this episode of The Agent's Angle.
Every week this happens, we have the show planned, and just as we have finalised our notes, another story nearly always lands in our laps before recording at the very last minute. So what was planned to be a shorter episode now grows as we again try to shoehorn in more topics that we feel are important to bring to you as they are current and relevant to the football agents world. But that, of course, means that some topics, material and guests may slip down to a later episode.
Yes, Jonathan, it's a time of year now where most of the big European leagues seasons are ending and agents are starting to get active, and there's a lot of stories out there, and we're going to go through a lot of matters. Actually, I saw on one WhatsApp group, I'm a member of, about 40 requests that come in for player types. So it's getting busy. I know, Jonathan, you would say that these WhatsApp groups, which list requests from clubs and types of players, are speculative. However, they're very common for smaller agents. And we're going to focus today on some key agent-related topics and stories. So, Jonathan, there's so much to cover today.
So to start off this episode of the show, we again take a look at what a happy, generous and friendly place the football agent world is. We're going to start off with a story that is older than the agent's angle itself, and one which we have been keeping an eye on. But out of fairness to all parties involved in the matter, as well as the legal proceedings, which in the end turned out to be a criminal hearing, we haven't covered this story until now, as we now have a ruling in the case. This matter first started to be reported on back in late 2022, and there were accusations of blackmail, but the charge that saw the police investigation and court case was then a lesser charge of malicious communication.
Yes, there are a few articles on this, and there's a bit of a timeline from the Daily Mail and the BBC. But let's give some background first. Football agent Saif Ruby was charged with malicious communications after police investigated allegations that ex-Chelsea chief Marina Gonovskaya was blackmailed over a £300,000 transfer demand. Now, the charge was malicious communications over a payment in relation to the transfer of Kurt Zuma to West Ham. Now, Mr. Saif Ruby, a prominent agent, was arrested in connection with the allegation, and he was charged with malicious communication, so not blackmail. And basically, it relates to an email that was directed, allegedly, from Mr. Ruby to Miss Gonovskaya, allegedly demanding the £300,000. Now, in these articles, it's been suggested that Mr. El Ruby, the agent, considered that he owed a percentage of the transfer fee and demanded payment from Gonovskaya. He insisted that he facilitated the transfer of the French defender Zuma in about August 2021, I believe, for about £29 million. Now, El Ruby stated before the court hearing and at the court hearing that there was nothing binding in the email, and that was the essence of his defence.
Personally, I thought when looking at the messages reported in the media, I thought they were largely innocuous. But to some outside of the football agency world, they may well have been perceived to be somewhat threatening. But I think we've both seen, heard and been told of far worse communications in this industry, Peter. Intimidation and threats far more direct and clear than the ones reported here, whether in an email, a text, a phone call, or even delivered face-to-face. And the tough, lucrative and competitive nature of the business sometimes leads to similar messages and behaviour, whether they be right or wrong, because the industry attracts a multitude of characters, personalities and approaches. The agent in this case, Saif Ruby, I've met him a few times, but I haven't dealt with him professionally myself. And we have a few shared connections, as everyone seems to in this industry. And in all honesty, from my few dealings with him, he's a confident guy and he has that swagger and confident character that I've come to expect from most agents. And some may not like what they perceive as a bit of arrogance, but a lot of agents have a similar nature. And it is the nature of the agent's world that arguably demands such an approach and persona at times, if not even adopting an alter ego, because otherwise there are cases where you will just get eaten alive. And some people choose a louder, more abrasive, if not aggressive approach. And dare I say, away from the business, agents, players, managers, club owners can be totally different to what they are in their professional role and environment.
He was, though, cleared of sending the intimidating email to Maria Sky. The court found that the intent wasn't there to threaten. Now, basically, he was concerned that he was effectively cut out of a deal and he was deprived of fees. All he wanted to do in his email was to convey a threat of impending legal action because he was frustrated at what was happening and he wasn't getting paid. Now, post the court outcome, Marina Granovskaya, who is the former director now at Chelsea Football Club, has said on the record that she does not miss the difficult and ugly side of football. It's interesting that Marina Granovskaya doesn't really speak publicly. Well, she was at Chelsea, I think, 2 decades and hasn't spoke much about this case or football generally since departing. In my view, Granovskaya's done a very good job at Chelsea and would have dealt with all types of agents. She would have seen it all, including obviously this incident itself, which was concerning, can be misconstrued. The agents at the top, or should I say all agents, want their fees. And sometimes it's a case of frustration or miscommunication that we don't get our messaging right. And I would say that as agents, we need to be careful with our messaging. Assertive emails on WhatsApp can sound abrasive very easily, even to the best of us. That's where sometimes you need to get on the phone, if someone's picking up, of course, to provide a little bit of clarity, context, and purpose around your communication. Because emails themselves can come across a little bit, difficult, Jonathan.
Yeah, the football agent world, what a happy, clappy, loving place in which we live. And if you believe that, you'll believe anything. The fact is that at times we all need to stand our ground, if not talk tough and be assertive, if not even a little aggressive at times. Would I have sent such messages? I would like to think not. I would like to think I wouldn't have reason to send such messages in the first place. But this case in itself was intriguing in many ways, not just with what was reported in relation to the case and some speculation in the run up to it. We had some witnesses from the agents industry reportedly called to give testimony, but not appearing due to illness, so some channels say, but then reportedly flying to the US by private jet and missing being called for testimony. But that aside, in the run up to the case, there was an interesting aspect of speculation for me as to what questions would be asked, the evidence required, and ultimately whether the alleged victims in the case would be as happy for the case to go away as anybody accused. Just 2 such articles. The first one in the Daily Mail, Chelsea may be forced to lift lid on Roman Abramovich's alleged questionable transfers next month in ongoing legal case. And then The Guardian, Marina Granovskaya linked to secret payments by former Chelsea owner Roman Abramovich. Now, we know there's been a lot of scrutiny on Chelsea in so many ways over recent years, both the old regime and the new regime. And the old regime, there have been lots of coverage of relationships with agents and alleged malpractice involving agents, some of which was from the Cyprus confidential investigations. So when I read that some in the media were reporting that Chelsea may be under pressure to reveal yet more details than they may be comfortable in doing so as a result of this trial, it added a whole new dimension. Personally, I don't think anyone involved in this case really wanted it to progress to a criminal trial. Was there a bit of bluffing and counter bluffing going on and it went all a bit too far? But when the wheels of criminal justice decide to start turning, it is really out of the hands of those involved, whether they like it or not. So I think this poses 2 key questions for me in terms of agents moving forward. The record keeping by agents in terms of communications with clubs. There's already the onus on agents to keep adequate records for the likes of the tax authorities. And from a sports regulatory position, much of the time, the onus is often inferred to be on us as agents to prove innocence rather than the authorities to prove guilt when it comes to breaches of the regulations. But also the tone and wording of our communications with the likes of clubs, players, and other agents. Some people are better at this than others, and it is a fast moving world, and we are all at times guilty of sending an email or text without thinking, as you pointed out earlier.
Yeah, it's interesting because once you run a case, there's always a chance that subpoenas can be issued and other people enmeshed in any deals will have to give evidence or other things have to be disclosed. And with Chelsea, it wouldn't be just this disagreement about the agent fees and a possible threat that was made. The outcome was obviously not guilty, but other developments in the club maybe brought some spotlight. And this also raised questions about the oversight of the club affairs by its boards. Courts can issue subpoenas and disclosure, as I said, and this affects people in the agents world, but also those who deal with agents in clubs. These days, corporate governance and director duties obligations are seen as important, I would say, in fact, fundamental when operating a major entity, including something like Chelsea. Also, reporting lines are always looked at. And this applies to agents and also football directors or people making decisions in clubs. You need to know what the end game is with these communications and how you're dealing with people. And we know this is an agent show and we're looking at how this impacts agents. And from the agent's perspective, we have to be careful what we send in an email, WhatsApp, what you file or lodge with clubs and federations and also other agencies, including tax agencies, because a lot of this has declarations around it. So you have to be very careful. For me, when working with different people, especially if you're part of an agency, who has the authority to communicate on what and who signs off any paperwork? Where is the source of power for you to make disclosures or negotiate or make decisions when you communicate with the key stakeholders? So, for example, if you've got a counterparty negotiated contract, where's your authority in negotiating and your messages coming from? And as agents, we're reminded it comes from either a club contract for a club agent or a mandate, or more importantly for most of us, the players' contracts. Our obligations, our messaging communications all derive from that. You can have your own style, Jonathan, the way you negotiate. Everyone's different, and we've seen all different types of agents, but it's a skill communication messaging, and you need to get it down pat. To know how to represent your clients effectively and have your bases covered, have both your paperwork aligning with your messaging and your communication, Jonathan.
With this case out of the way, the other thing to consider here is whether the football authorities, such as FIFA and the FA, look at matters relating to this case, whether they be direct or indirect, or whether it would draw the gaze of others, such as the likes of the tax authorities. The former, probably not, but I'm not going to go there today. The latter is more likely, in my opinion. And on the topic of the tax authorities, there was a release just yesterday at the time of recording from HMRC, which, for those who don't know, is the British tax authorities. And this update was specific to football agent matters. And we know HMRC, like other tax authorities around the world, have been more alert to and aware of football agent related matters in recent years. And I think this is an important bit of guidance issued that agents, not just those based in the UK or with clients in the UK, but those who may be doing football work in the UK, as we know many want their clients to make it to the likes of the English Premier League. I will try and keep it as concise as possible, as the information is openly available. Plus, we talked about agents and tax back on episode 26 with Pete Fairchild. But some key observations for me from this information released by HMRC are as follows. Now, the overall tone and language HMRC used in most of this update seems quite conciliatory and more cautionary than in the past with HMRC. An interesting thing to start is that the update itself doesn't just address agents, and they are also seemingly directing the communication at clubs, players, managers, coaching staff, and others, which includes professional bodies that represent and advise. So maybe that's the likes of player associations. So I don't think this is an anti-agent witch hunt by HMRC. I think it's a topic of agent-related matters that they're focusing on. They do highlight the various tax elements that they are looking at, which in my recollection hasn't always been the case of them being so definitive. And with that, the main elements they highlight are the income tax, the national insurance contributions, the VAT liability, and the entitlement to reclaim that VAT. So that says to me, once they are alerted, they're going to look at every tax element. And they actually give some useful yet basic examples of the different tax revenue losses that can be experienced from an agent perspective through malpractice. The key focus in the release from HMRC quite clearly seems to be duality or dual representation, which has been a big bone of contention for HMRC for many, many years, I think it's safe to say, really since it was first permitted under FA agent regulations in 2009, I think it was. Firstly, HMRC confirmed they do recognise the dual representation concept, but do not accept a 50-50 split as the default. This 50-50 myth has long been peddled and believed by many in the agents world. And I know it was never an official default value at HMRC, as I've had these conversations with key HMRC officials who led this process for many years. Also, HMRC clearly reiterates their view that generally the agent is primarily representing the player and acts in the player's interests, and the bulk of the agent's work, in HMRC's opinion, will be for the player. Hence, what HMRC are keenly focused on with this update is reinforcing the fact that agents, clubs, and players have to be able to substantiate the commercial reality, which I think will become a common phrase in the agent lexicon, of any dual representation, both in terms of who the agents work for and what services they provide. And one particular extract here from HMRC that drew my attention, and I think it might draw the attention of many agents, old and new, is that clubs and agents often claim negotiating the contract between the player and club, the agent has provided a valuable service to both parties, which is a mantra I've heard presented by many agents and clubs in the past, going back many years. However, HMRC's view presented in this update is that, and again I'll quote, the agent providing services to the player may be of value to the club, but it is not an automatic indicator of the agent providing services to the club. An interesting quote and wording, I think you would agree, in the context of dual representation and the agent-client relationship. The other big factor in this update is the matter of documents, evidence, and record keeping, which HMRC stresses repeatedly throughout, and that in their view, there is often not enough evidence of commercial justification being provided to prove the agent fee split. HMRC expect the parties involved in dual representation to retain a comprehensive audit trail to support claims of dual representation. Now, this will include, and this is not an exhaustive list as I understand, the player-agent representation agreement, the permission given by the releasing club to the engaging club to approach the player and agent, the engaging club's initial approach to the player and agent, plus the terms offered, the club requests for the agent to provide services, the specific services to be provided to the club, the amount the club would be content to pay for said services. The agent agreement for dual representation, including the type of services, initial terms, final agreed terms, valuation on services to both the player and club, the player's agreement to enter into dual representation, the dual representation agreement between the player, club, and agent, and the player's agreement to enter an employment contract with the club, including the initial terms and final agreed terms. And an important thing to note is that HMRC expect this is evidence to be obtained before the agent provides any associated services to dual representation. The employment contract, of course, being the notable exception. As such, a dual rep document with the same date as the player's employment contract is a red flag. And although they don't use the term red flag, that is exactly what it is. And reading between the lines here, it is seemingly a clear warning from HMRC. So this evidence, what can it be? Brace yourselves here. It can be emails, contracts, letters, faxes. Do people still use faxes, Peter? Memos, meeting notes, notes of telephone calls, text messages, which includes messaging apps. Both the agent and the club are expected to retain the evidence stated. Hence, as I said earlier, this update doesn't just address agents.
Yes, it addresses everyone involved in the player transaction. But I have to laugh a little bit, Jonathan, because you mentioned faxes not too long ago. We were using faxes. In fact, FIFA was very big on faxes. I've got a couple of documents from FIFA on faxes that I've kept. So that was quite interesting that the HMRC, which is the United Kingdom Tax Office, has also suggested that. Overall, it is a two-way street. Documents have to be kept by both sides to see if they align. It's a bit like the TMS, where when you lodge a transfer, the two clubs upload certain documents and then FIFA checks if they align. I think HMRC, a similar style, where they'll get the documents from both sides, the agent or the multiple agents, if that's the case. And then the club, and if obviously a loanee club as well, there'll be a second club involved. And those documents will be audited or reviewed to see if there's an alignment in the way things were paid, Jonathan.
And away from the dual representation aspect and those technicalities, we then have a section that specifically references the FA football agent regulations in England. And to paraphrase in a very crude way, I interpreted it as follows. The FA agent regulations of January 2024 are all well and good, but following these regulations does not make you exempt from the need for HMRC compliance. And again, this goes back to the need to provide evidence of commercial reality on agent dealings and reaffirms this 50-50 split not being a default position regarding matters of dual representation, no matter what the football agent regulations say or allow. And on the topic of the English FA, we have it on very, very good authority that we should expect an email from the FA in England to all licensed agents registered with them in the very near future on this HMRC update. And everyone must note, as we've mentioned in past episodes of the agents angle, that being a FIFA licensed football agent does not automatically make you a licensed football agent in England, as recognised by the FA in England. There are a couple of additional administrative steps to take, nothing too taxing if you pardon the pun. But I'm very confident that an email will drop into the inboxes of those licensed agents registered with the FA in England, possibly before this episode of the Agents Angle is published. So agents should keep an eye out for that email, as I know a lot of people skim past emails from the likes of the FA rather than take the time to read them. But based on past experience, it will most likely be just a pointer email to the web pages of HMRC and deflect any queries there, or even be used in a way to reinforce the reporting obligations that exist for licensed agents under their national football agent regulations, which in itself, either the NFAR in England or the reporting obligations and the forms therein are a topic for another day. But I digress. So back to the actual update and the guidelines from HMRC. Then there is a reference to something new for me, shadow agents, which is, as I said, a new term. But how I interpret it is that these are subcontract or partnership agreements between multiple agents, or heaven forbid, unlicensed agents.
If I can butt in there.
Go on.
I think it's unlicensed agents or people in the shadows acting as advisors, but not putting their names on the paperwork. And HMRC understands that these type of operators exist. Not sure if FIFA has been able to enforce anything against unlicensed agents in the past. Interesting what happens in the future, but HMRC maybe understands the dynamics a little bit more, that some of these operators, some nefarious in fact, are out there.
Yeah, and in such arrangements, it does say that these increase the likelihood of compliance checks. So if you are involved in any of these arrangements, whether they be legitimate subcontract partner or mandate agreements, be careful with your record keeping as an agent. Then it talks about loan players, and if as an agent you have a player client who is on loan, HMRC sees the focus as being on the parent club. But I think agents should have that audit trail with both clubs just to be on the safe side. Then there is a reference to family members acting as intermediaries, which I thought quite strange, as it should now be licensed agents, whether they're family members or not, after January 2024, unless on a pre-existing agreement or contract which still has time to serve. We aren't going to play dumb here. We know these things happen, whether pre-2015, post-2015, or even now, with the likes of some agents or some clubs in some way greasing the palms of family members. But all I will say is that if the likes of HMRC are quoting on it, then the football authorities should be well aware of it and be seen to be doing something about it. So my immediate reaction to this is that, taking into account the general tone here from HMRC with this new information, this is potentially a sign of HMRC going to be very clinical on agent matters in the UK, and in particular target duality and dual representation.
It's a must-read guide for all agents who seek to do business in the UK, but also those who want to create better compliance for their records. So I urge anyone to have a look at it. And as you said, it will be in the show notes. But it's showing what's happening, not from FIFA, but from other regulators. We talked about anti-money laundering legislation coming on board. Now we have the HMRC guidelines. As a lawyer and agent myself, I'm not an accountant, I'm actually impressed with this guideline document, I have to say. For me, although the cap is gone in England on agent fees, the other regulations, including the new rules that may come in the English Premier League about how much wages clubs can pay, and then this guide is changes that maybe FIFA couldn't implement. So there are still regulations out there, or in this case, the tax office, which will look at commissions. And you also mentioned family members. Now that's interesting because in the guide it says any payment to a family member, and we know family members must be agents now, they must be licensed, that will be taxable as employment income of the player. So there is a direct mention there that the player is responsible for any payments to a family member tax-wise. And the last thing, outside of England, because I'm not based in the UK, I should say, what impact this guidance has. I think all agents who want to deal in England have to be across it, but it also has got a bigger picture to this. That if you send an email, if you've got paperwork, if you've got invoices, if you've got a trail of documents, you need a good filing system as an agent for each client, independently, each client, not just one whole bunch of documents. And for those who outside of England who are FIFA football agents registered or have a license and want to register in England, they should also look at these guidelines, because any deal that's coming from outside into England, this guide affects you and the tax treatment of any commission you make, Jonathan.
So with news of one agent-related court matter out of the way, and more information for agents to consider in terms of tax regulation to avoid penalties and possible prosecution, we're going to mix the two up and go back to a different type of court case. This time one more focused on football governance and regulations. And this involves, dare I say, the ECJ, the European Court of Justice, which, if things carry on the way they are, football will have its own courtroom at the ECJ, with all the hearings going on there recently and in the foreseeable future. But there was another announcement this last week or so that could be huge in the weeks, months, if not years to come, not just for agents, but also clubs, the football authorities, and ultimately players. And dare I say, Peter, this could trigger the next Bosman-esque type change in football.
Yes, huge, I would say, and very important because we agents are involved in the transfer system. So what we're referring to here is the European Union Advocate General opinion that came out last week, as you said, Jonathan. It's by the Advocate General Marseille Spruzna, I hope I pronounced that correctly, that some FIFA rules on transfer of players may prove to be contrary to EU law. That these rules, and when we're talking about the rules in questions, are the regulations on the status of transfer of players, in short, RSTP, which I'll be referring to going forward, are the important rules that agents and clubs and everyone in transfers works with. That these rules are restrictive and may only be justified in specific circumstances. Now, this basically opinion came out of a French soccer player, Lazana Diarra, who ran a case that legally challenged the FIFA rules. And we'll go through those, but give some background here. He had signed for a Russian football club, Lokomotiv Moscow, only see that his contract was terminated by this club 1 year later for alleged breach, and termination of the contract was the issue. The deal was terminated a year later after the RO was unhappy with the alleged pay cuts. Now, Lokomotiv Moscow went to the FIFA DRC, Dispute Resolution Chamber, for compensation. The player then submitted a counterclaim seeking compensation of unpaid wages. So that was the case. And he argued, obviously, any compensation for a breach contract by him for wanting to terminate his contract unilaterally would cause damage, not just to himself, because he had to pay there's a penalty, and we'll go through that, but also any clubs that may have induced him leaving Lokomotiv Moscow. Now, he claimed that there was a deal with Charleroi, the Belgian club, and it fell through because the way the RSTP conditions are set out about how you terminate contracts justly or unjustly. And so he sued FIFA and the governing body of Belgian football for damages and loss of earnings. Now, this, as you said, Jonathan, went to the European Court of Justice. There's that opinion, the Advocate General, and he gave an opinion which will guide the court in having a look at this matter. And part of it is FIFA's rules governing contractual relations between players and clubs. The Advocate General Spruzner said that these rules in the RSTP may prove contrary to European rules on competition and freedom of movement of persons, and that they're of restricted nature, because they have sporting sanctions in terms of not allowing hiring clubs to take on a player like Diarra after he induced a breach of his contract, but also affecting him as well with the penalties. Now, there's a couple of articles that talk about this. We've got the opinion. And as I mentioned earlier, Diarra claimed in his suit that the new club was hampered by the FIFA rules because if he signed anywhere else, the compensation that was ordered by the Court of Arbitration of Sport, they found that the player had to pay €10.5 million, to the Russian club, that no club would take him on because they wouldn't want to pay that compensation to Lokomotiv Moscow. Now, this is an issue of when you terminate a contract of just cause. And this issue was found by the Advocate General, Mr. Spruzner, that it's hard for players to move because of this, and it restricts players' EU rights, European Union right to move across the bloc. Now, this is an opinion only. It's not the final decision of the European Court. But what happens is if the court looks at this, says they agree with it, it's going to have major implications on the FIFA regulations on the status of transfer of players. Now, we know as agents, we're at the forefront of presenting players. So this case has significant repercussions. I mean, obviously, you had the Super League, you've got the agent fees, the caps, that's going to the ECG probably next year. In this case, when a final decision is made about whether parts of the RSTP are anti-competitive, are game changers for agents to a degree, because the RSTP is the most important framework for me, and we're all affected from an agent's perspective.
The strange thing for me on this one, Peter, is that it seems to have passed a lot of people by. Maybe it's because of the other news stories involving football regulatory matters at the moment, such as FFP and profits and sustainability, potential salary caps, and of course, those four letters that dominate this show and the agents' world at times. No, I'm not going to say it. I'm not going down that rabbit hole this week. And even though the Advocate General's opinion isn't indicative of how ECJ rulings will go, I am told it's a good guide of which way the ruling may lean. But this case goes back some way, and the regulations relating to it have changed over recent years. Yet there are key aspects that agents need to be aware of and understand in terms of player clients and their rights in similar situations. So, do you want to give a brief overview in as straightforward manner as possible in regards to the case and the regulations that apply, which I think are mainly 14 bis and Article 17 of the RSTP?
Yes, two key issues relate to the Diarra case, as you mentioned. I'll start with Article 17 of the RSTP, which governs the consequences to a player of terminating a contract without just cause in this instance. Basically, if you terminate without just cause, there's financial consequences, in this case for the player. But also there is other sanctions called sporting sanctions, but I'll tackle one at a time. So if a party, in this case, it was alleged Diarra, terminated without just cause, they're in breach of their contract. So when they breach their contract, in addition to the financial consequence, and I mentioned the amount the Court of Arbitrary Sport found against him, they can also have sporting sanctions imposed. And these sporting sanctions can be a suspension of play between 4 months normally to up to 6 months if there's aggravating circumstances. So agents need to be aware of this article when negotiating contracts, because it's not just a financial issue, but also the punishment of sporting sanctions if there is a breach. But also, how does this relate to the case is it prohibits players from playing or clubs from acquiring new players for set periods of time. The goal of Article 17 is to have contractual stability, so players can't just walk away and terminate unilaterally. But when you're looking at it from the European court point of view and competition law, etc., penalties like sporting sanctions may be seen as an issue. And that's why this is something that's going to be looked at in the case. And I mentioned it could be out for 4 months or up to 6 months. And it takes effect immediately, so your career will be hampered. The second article you mentioned is Article 14 bis of the FIFA regulations on the status of transfer players, the RSTP, where a player is deemed to have just cause for termination when his club fails to pay at least 2 consecutive monthly salaries, as long as the player or their agent, a lot of times the agent or the lawyer, has sent a default notice within, I believe it's a 15-day deadline to remedy the debt. That is the club to remedy the debt. Got to give them a 15-day deadline if 2 consecutive monthly salaries have not been paid. However, there is a limitation here. A player cannot prevail himself of this mechanism if the club had legitimate grounds to reduce his salary because of, we had the pandemic before, disciplinary action, or if some of the payments were executed in the last day of that 15-day deadline. So these are seen as probably anti-competitive from the player's point of view. And we'll find out what happens with the European Court of Justice when they hear this case. But these articles are fundamental to the RSTP. So this case is very important going forward. And what will happen, I don't know, Jonathan, but as you said, it's very Bosman-esque.
Maybe I'm demonstrating a bit of non-legal naivety here, but for me, I've always thought that these rights are more weighted in favour of the club than that of the player and subsequently the agents. As in a contract, it is my view you enter a contract with another party in good faith with a view to honouring that contract. If you breach it, you face the consequences. If the other party breach it, you expect to be adequately compensated. But it isn't so simple in football, is it? As we have in this regards, the difference between sporting just cause and just cause, and also protected periods as per the likes of the Webster ruling. Plus, these regulations have been modernised in more recent times to address those aggravating circumstances you spoke about. For example, the players being forced to train alone or with youth sides, and on the flip side of it, players effectively going on strike to force through a transfer. So again, avoiding the legalese, can you run through those 3 core elements: just cause, protected periods, and the revisions of more recent times?
Okay, I want to mention just cause in one other context, and this is because I have to say it. The FIFA football agent regulations also mention just cause, but I'm not covering it. But as agents, we need to be aware that if an agent causes the breach of a player's contract without just cause, they can be disciplined. This is an issue for another day we can discuss, but just cause has come into the FFAR, not just into the RSTP. Now, here we're referring to the RSTP. Agents, we need to know the FIFA law. Not fully, but we need to know the mechanism, especially when players are not paid. So just cause gives you the right for a termination. It's not defined, but the major way that you could use just cause to terminate contract as a player is when you haven't been paid for months. And I've said that you won't have compensation or you won't be in the position of a sporting section as long as just cause is found. Now, you mentioned abusive conduct can also be a way of terminating the contract of a player or agent helping a player terminate their contract, especially if there's just cause. Now, I mentioned if you haven't been paid 2 months' salary and you give the right notice period, that falls into the just cause ambit, I would say. But abusive conduct, that's a little bit different. The major scenario is when a player from the first team has been abused allegedly by the club, what type of abuse and conduct has occurred. Maybe they were sent to the reserve team or youth team. They were asked to train alone. So you look at when was this implemented? Was it during official matches? When you're trying to prove abusive conduct in order to terminate a contract. And agents have to be across this because we all have players approach us. They're not being treated well by a coach or a club. However, you also got to look at it at that time if they're being paid their full salary and receiving all their other contractual benefits. When someone's been ostracized at a club or made to train alone or with the youth team, is it a permanent or temporary measure? So these are all things we look at before you can say there's abusive conduct and I want to make an application to terminate my contract as a player without any penalty applying. Were the adequate training facilities applied to the player? Is the contract that you negotiate as an agent allow the club to have the player train with the youth team or drop to the reserve team? That's important for us agents to look at when we do draft a contract or we suggest amendments to a contract. So these are very important. We have to be across these issues because a player who's out, who's been dropped, can be demoralized and in a very difficult situation. And you mentioned the second point, sporting just cause. So someone wants to move on because they're not playing senior teams football. This is Article 15 of the RSTP. You can terminate for sporting just cause, but it's very rare. And you haven't played in less than 10% of the club's fixtures in the relevant season. So this allows you can terminate a deal or a contract without the fear of potential sporting sanctions, which I mentioned earlier. Now, sporting just cause, it has to be you're an established professional, less than 10% of official matches, but that's calculated by not the number of matches. It's calculated according to the time on the field. So you've got to look at the whole time of the season, and if it's 10%, so you've got to be careful of that. That's just anecdotal, but you need to know that. Now, as an agent, if a player's dissatisfied, they're not playing many games and they're falling below the 10%, you need to notify the club of that. That's very important because you just can't assume that they know you're playing less than 10%. Now I'm terminating. Sporting just cause is found rarely by the courts. There's not many cases and you have to be very, very careful. Now, what if you're an agent, you've been proactive and you've said to the club in the contract, and it's been put in the contract that you can only train and play in the first team and cannot be demoted? That's an interesting one. I haven't seen that in the case of sporting just cause or whether someone can unilaterally terminate a player, in other words. But that's an interesting case going forward. Now, protected periods. We know the protected periods are for mainly the big contracts, longer contracts, the big 5-year contracts. A player who's terminated contract without just cause shall in all cases pay compensations to the club if they terminate within the protected period. So it's important for agents working with the big player who sign long contracts that they know what they're dealing with. And especially with the top players, most of the top players, say the top 100 players in the world, most clubs who want to sign or transfer those players into their club will want those 5-year deals. And that's where the protected period is very important, which is 3 years within the 5 years that you can't really terminate unless obviously you're not paid or something, because otherwise, without the club agreeing, you could be having a sporting sanction, because sporting sanctions are imposed on any player found to have terminated their contract without just cause during the protected period. So it's defined in the FIFA regulations as 3 entire seasons or 3 years, whichever comes first, following the entry of the force of a contract. That's for up to players for the 28th birthday. It's 2 years if you're over 28. So that's the protected period. And in the protected period, an agent needs to ensure that they've got bonuses, pay rises, sell-on clauses, transfer clauses, all those things down pat. Because if there is a move, there are other mechanisms to get a player club before the protected period of, say, 3 years ends. So we need to be across, especially when you've got big players who are given 5-year deals, as we know clubs do, that you understand the protected period. The final matter I'll say is there's aggravated matters. There is some changes there, but basically most players, if they terminate a contract without just cause or during the protected period, etc., it's normally a 4-month suspension. If there's the second time you do it, 2 consecutive contracts, which is rare, it's up to 6 months. Now, for all the agents out there is a good resource, and it's not just the FIFA RSTP. There's the FIFA commentary, the 2023 edition on the FIFA regulations for status and transfer players. Have a look at that. That is a big document, huge document. It's got all the scenarios about what we've just discussed, and I would recommend, if you've got any issues, to read that. Will save you time and will save you heartache on deals to understand all these concepts. Just clause, sporting just cause, aggravating circumstance, protected periods, when you can terminate, what is Article 17, what is Article 14 bis, and what will change if the European Union Court, the ECG, decides against FIFA in this Diarra case.
As I said, I think out of all the things we covered in the last year, this could potentially lead to the biggest shake-up in football regulations and have a big knock-on effect for the agency world. Whether you look at it on its own and the potential for it to be the next Bosman in terms of player rights, if not, dare I say, power, and how the transfer system operates. And I was actually on a webinar just yesterday where several respected legal and academic minds shared their views on this case. And there were some very interesting takes from the applicability of CBAs, collective bargaining agreements in football, through to the potential collapse of the transfer system as a result of this case, and also questions over the legitimacy of FIFA in the transfer system. But several other interesting, if not crucial, things came out of that webinar. The first one is that one of the lawyers involved in the case is Jean-Louis Dupont, who many will know, but if you don't, he actually led the Bosman case. There were some representatives of FIFA who I noticed seemingly snuck into that webinar to see what was going on. The belief was that the Advocate General's opinion and the findings in several ECJ football cases that have already received judgments are starting to show a pattern in the train of thought of the ECJ with a lot of these disputes, and they do actually link together. There's a clear and important involvement of FIFPro in this case, and the role FIFPro have to play, I believe, in so many matters moving forward is growing. And something I wasn't aware of until yesterday in this webinar is that the French trade union have lodged a criminal complaint against players being pressured by clubs into accepting reduced terms and contract renewals, amongst other things, and how that impacts on this case, others, and RSTP, and football regulations as a whole moving forward.
It's all happening, Jonathan, on all fronts, actually. So the lawyers will be happy. There's so many cases going forward. But yes, I wasn't aware of that either. Agents, as we know, we have to deal with players who are being harassed, bullied, sidelined, demoted, ostracized. I mentioned that before. They're asked to move on or to renew a contract. The club really wants to sign them because they see a lot of potential down the track for a transfer fee. Now, there's a few articles. One's from Le Monde, the famous French paper, and it does talk about the France's Union of Professional Football is launching legal to protect players from mental pressure their clubs put on them when they're cold-shouldered until they sign a new contract or are pushed to leave. Obviously, signed players can be pushed to leave even though they've got a contract in place. This legal action, as the article says, does not target a specific side. The union just wants to highlight bullying that players have to endure. And they believe this type of behavior by clubs, enforcing to extend deals or pushing on a transfer, is contrary to the French football charter and employment law, and may be a criminal offence. Then there's another article in Slovenia. The union there takes criminal action in club for first time as footballers fight widespread abuse of rights. And the Slovenian Players Union put this article as well on the show notes. It's by Colin Miller in the New York Times that the Slovenian Players Union, SPINS, nice name, has filed a criminal complaint against the national champions and historic club Olimpia Ljubljana, who they say is alleged of bullying and harassment, humiliation of 4 players. SPINS has filed criminal charges against the club and its manager, accusing them of leaving players out of training sessions or camps in an attempt to get them to leave or sign new contracts. Olympia, entitled to reply to that complaint, have not responded as yet. We see as agents a lot happening in training session or camps. So this is very prominent, and it's good that player unions are getting involved. But agents need also to be proactive and pushing and making sure clubs don't engage in this kind of behaviour. You mentioned FIFPro article as well about the French Players Union filing the criminal complaint. What I saw there is that this season, 180 players in France have been put under pressure to accept new contract terms or a transfer move according to the FIFPro or the French Players Union. And these practices are widespread. 180 players. That is huge. And one of the most prominent in this article, it's mentioned, is Kylian Mbappe, the FIFPro article, who last summer was banned from the first team from Paris Saint-Germain for 24 days because he refused to extend his contract with 1 extra year until 2025. Very interesting.
Football, such a happy world, at least for the lawyers anyway. But we did warn you, folks. We did warn you that there was a lot to cover and it was a long episode. But finally, I can see him chomping at the bit to get going on this, like an Aussie seam bowler facing an English tail ender. It's time for Peter's quick picks. So, Peter, what have you pulled out this week?
Yes, it's a segment of actually quick takes. I called it quick takes as last week. No, quick picks, quick takes, and pretty much putting the magnifying glass on interesting issues and trends that cover the agents world. And I'll start with one interesting one from my side of the world very quickly, that the new Australian A-League club that's coming on board next season, Auckland in New Zealand, which is actually owned by Bill Foley, who owns Bournemouth, setting an example of how they, as a new club, of handling agent matters. And we really see brand new clubs, other than, say, the MLS or the USL franchise in the USA, coming on board, brand new clubs. In this case, Auckland, they've targeted, and my feedback is, and my dealings and close associates, they have a player list, and they also focus on young New Zealand players. Now, they've been approached by over 100 agents and players randomly, and really that makes it very difficult. But to understand new clubs, Auckland in this case, as agents, have a blueprint. So before people approach these type of new clubs, they need to understand what Auckland are about and what blueprint they want in the players they bring in. So as an agent, this quick take is about got to know what the club is seeking, and that may be asking New Zealand or Australian agents who have a bit more experience in this side of the world with this type of new club. Now, I've heard that, and I think it's till now, the football directory is down, the FIFA Football Agents Directory. I wanted to check if a person was licensed, and it was still down because a potential client wants to know if they got a FIFA license, a player agent's license. Now, we need the countries also to get involved here, the national federations. And one that has is Kenya, who've listed who are their FIFA accredited football agents. So when something like the directory is down, we need to have a list of see who's licensed, because you can't work otherwise. Players need to check, clubs need to check, agents need to check, and it's down. Now, that's not all my quick takes. This is a major take, I would say. There's one story or topic or theme that we've always wanted to cover, and that is Mino Raiola. But in this case, Zlatan Ibrahimovic confesses, it's an article, missing his late friend Mino Raiola. Zlatan Ibrahimovic, former player of AC Milan, Swedish national team, Barcelona, opened up recently about the passing of the agent Mino Raiola. He admitted Raiola's passing was a huge shock and that he misses him. If he could text him now, he would said that, I miss you. Now, we know Raiola is famous for having a lot of good clients, top clients, I should say, top shelf clients, Erling Haaland, Pogba, Mkhitaryan, Berardi, Donnarumma. I won't go into them all. We know Ibrahimovic is now retired and joined the board of directors of AC Milan. But there's a side story to this quick take. And this is important for all agents, not because it's Mino Raiola, it's how they started. He was looking for a new agent, that's Zlatan Ibrahimovic. Someone suggested Raiola and a few other agents. So when they met, Raiola didn't pander to anyone, even though he knew the reputation of Ibrahimovic. There were some words mentioned, this is an article in Talk Sport, that Raiola told him after the conversation, go F yourself and stuff it. And because of that, both of them coming from, I suppose, grittier upbringings, there was a connection because none of them felt that anything for them was given on a plate. So a connection was made. And not only that, Raiola told Ibrahimovic that his statistics were rubbish and that he needed to head down to work and forget about flash cars and expensive watches. And he basically pulled out a paper and told Ibrahimovic, look at these players with great statistics, I should say, not stats. He showed games and goals of Shevchenko, Inzaghi, Vieri, and told Ibrahimovic, this is Raiola, how can I sell you if you don't have these statistics? Now we know that the relationship between Ibrahimovic and Raiola was just at another level. He played for the biggest clubs, but it just shows how you can start off with a player and where you can end up. Obviously, it's the Raiola example, but it's an amazing thing that, you know, a lot of agents look up to Raiola, but also how you can connect with the player. So very interesting. Now, a couple more. I'll be quick. We've been following the relevant case. And FIFA's told the judge in the relevant case is where Relevant Sports wanted to play a competitive fixture in a La Liga fixture in the USA. But FIFA's come to an agreement with Relevant Sports, and they've now told the judge they're going to change the rules barring clubs from playing abroad by the end of the year. This is an antitrust case, or in Europe, anti-competitive case, and the rule change is going to happen quicker than we think. So there's another big step. Competitive games played abroad from leagues. I know La Liga's got that ambition, and you've mentioned before, English Premier League, always thinking about fixtures abroad. This will happen very quickly. So FIFA's moving again on antitrust cases. And I want to mention one last quick take. It's TFF, the Football Forum, which is one of the leading agents association in the world, have an interesting UEFA affiliation for their player agent program. It was published yesterday. Everything happened yesterday. There was an initiative between TFF, the Football Forum, and the UEFA with its UEFA Player Agents program, which is now open for application. So anyone interested in that program should apply. There's a possibility that senior members of TFF may come onto the course. It's a very interesting move because we know TFF represents pretty much all the super agents, and whether they will be part of the course, I'm not sure, but it's a game changer for those applying and who get in, because the mentorship and the connections and the networking and the knowledge now for that course will be at the stratosphere, Jonathan.
And on the point of knowledge, I think it's only right to point out that on the relevant case, Peter, you actually called it once again in the last episode before that article was released. And you intimated here on the agent's angle that the settlement by FIFA and Relevant may include FIFA rewriting some of their rules on where official matches could be played. And this seems to be a similar approach from FIFA that they took with the ESL case, albeit in that case, they changed the rules after the judgment was passed rather than part of the settlement, if I'm not mistaken. And the other matter is in regards to those comments from Zlatan. And it just impresses on everyone how important the relationship between agent and player is. And for all the criticism and scrutiny Mino Raiola got from some quarters, that story and the success Ibrahimovic experienced has showed that Mino was obviously doing something right. And we were planning on doing a special episode solely focusing on Mino on the second anniversary of his sad passing, but we just couldn't get the content to do him justice at the time. He was a trailblazer for the industry and played a huge part in shaping so many aspects of the football agents world.
Yes, it was very difficult, John, to get the right mix of content to a specific Mino Raiola episode justice and present the correct and fair narrative. I'm hoping by just putting this article in, at least, we've given some context of how powerful Raiola's relationship building power was and his effect on the agents industry. We've given a bit of flavour of his relationship with Ibrahimovic. And, you find these stories sometimes, they're in the media, that there might be sometimes exaggerations, etc. However, Raiola, as you said, was a trailblazer and really had a huge impact on a lot of things in football agency. A lot of people miss him, as a lot of people look up to him. So it's good to cover at least one player he dealt with, Jonathan.
And I think that's quite an apt point to bring this episode of the Agent's Angle to the close. It's been a busy episode. It's a lot of content to go through there. As I said, we do try and bring it to you as soon as it drops and when it's relevant, but that obviously means things get pushed back. As always, please do follow us on the various social media channels. LinkedIn is probably our most active channel, and if you do have any questions, please do contact us, or any guests or topics you want covered on the Agent's Angle, we'll do our best to facilitate. A busy week ahead for me, as I'll hopefully be attending the Law in Sport Football Conference in London this coming week. So if you are there, please feel free to say hello.
Yes, good luck to those sitting the upcoming May exam in a week or so from the time of recording. We actually hope to have some new guests and cover some new intriguing markets and agents in future episodes. So it's bye from me.
Yes, if you are sitting the third FIFA Agents exam in a few days' time on the 22nd of May, the very best of luck, and I hope the questions fall fairly for you. And if it doesn't go to plan, it really isn't the end of the world. Still lots of things to be sorted out in the industry, and there are plenty of opportunities to work in the football industry, if not in a role connected to the football agency world where there is an agent or not. So for now, take care and goodbye.
The purpose of the Agent's Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.